Hey now, this is Professor Nathenson. This is, I believe, video number 9 in our series of discovery videos. This will be a short one. We have just a couple to go. Those will be mostly short as well. This video is on Rule 35, physical and mental examinations. All right. First question, when is a mental or physical examination appropriate? See Rule 35A. Let's go right there. The court where the action is pending may order a party whose mental or physical condition, including a blood group, is in controversy to submit to a physical or mental examination by a suitably licensed or certified examiner. Okay, so the mental or physical condition, one or the other, or both, has to be in controversy. All right, now there's a couple important things to note here. The first is to get a physical examination via discovery, you can only get it of a party, or as we'll talk about, somebody under the party's custody or legal control. Okay, so in this respect, Rule 34 is kind of like Rule 33, where you can only seek interrogatories from parties, and Rule 35 mental exams is kind of like that as well. Put differently, you can't force a physical or mental examination of a non-party witness. It's got to be a party. All right. Second, it's mental or physical condition being in controversy. And third, you can't just notice physical or mental examination. Normally, you send a notice of a deposition to the other side and the court's not involved. Or you send interrogatories to another party and the court isn't involved, right? Or you're going to send document requests to the other side or to a non-party witness, and the court is not really involved, okay? But the court is involved under Rule 35 for physical and mental examination. You have to ask the court, okay, to provide an order. So you can't just tell the other side, hey, I'm going to examine you. You have to get a court order. All right. Who is subject to a physical or mental examination? Okay, now we're going to get to that sentence I was just talking about. The court has the same order or authority to order a party to produce for examination a person who is in custody or under its legal control. Okay, well, what does that mean? For example, suppose you sue plaintiff versus Walmart, okay, and you want a physical examination of the driver of a car, or rather of a Walmart truck that allegedly ran into the plaintiff's car. But the defendant here is not the driver, it's Walmart. All right. Well, you can't really get a mental examination or a physical examination of Walmart. It's a corporation, right? What about a mental or physical examination of the driver? You might argue that the employee is under the custody or legal control of the employer, but that would not be correct. There had been suggestions to amend Rule 35 to include the right to seek examinations of employees. However, those suggestions did not go through. Employees are not in the custody or the legal control of their employers. Okay, keep in mind, 13th Amendment, slavery is illegal in the United States. All right, you may work for a company, you may work for St. Thomas University or for Walmart or for whatever, but your employer does not have legal control over you. They cannot compel you to do things, right? You're not in their custody in the sense of being a child and you have a parent who's your guardian and the guardian has custody of you, right? You're not in custody in the sense that you're a prisoner in a jail where the government has custody of you. No, the employee of Walmart is not in the legal control or the custody of Walmart. And the same is generally going to be true if you sue, say, spouse number 1, okay? Spouse number 1, and then you want to seek that mental exam or physical exam of spouse number 2. Again, that's probably not going to fly. All right, now, if, say, plaintiff versus defendant for a car accident, and the plaintiff is alleging, say, negligent infliction of emotional distress for an accident involving the child of P. So C of P, child of plaintiff. All right. Well, in such a case, defendant might be able to get a physical or mental exam of the child, because now the child is somebody who is in the custody or the legal control of the plaintiff here. Okay, so the words do matter here. All right. Is a court order required? We've already noted that. All right. Provide an example of a case in which an exam would be appropriate, an example of a case which an exam would be inappropriate. Well, here we have to pay close attention to the words mental or physical condition is in controversy. And that's a pretty discerning standard. You know, that probably is even narrower than the Rule 26b1. Remember, Rule 26b1 requires relevance to any claim or defense, right? Not privilege, and proportional, okay? So at a minimum, discovery always has to meet all of these 26b1 conditions. But under Rule 35, we're not asking for things that are just relevant. You know, relevance is always required. Now, the mental or physical condition of the party has to be in controversy. So it's not enough for the mental or physical condition to be relevant. Additionally, there's got to be dispute over that mental or physical condition. So here's an example of where there might be a dispute. Plaintiff sues a defendant for negligence in a car accident, right? Defendant's answer says plaintiff was contributorily negligent due to bad vision, right? So D's saying that plaintiff has bad vision, and plaintiff's bad vision meant that plaintiff was driving when plaintiff ought not to have been driving, and that constitutes contributory negligence by the plaintiff. Okay, and then the plaintiff during discovery, say during a deposition, in P's deposition, P says, my vision is great. You know, so we have now the plaintiff under oath saying my vision is great, whereas the defendant in the defendant's answer is saying that the plaintiff has bad vision. Now vision is in controversy, right? It's not just relevant, the vision, it was always relevant. Now, because the plaintiff's deposition denies there being bad vision, because the plaintiff denies having bad vision, now vision is squarely in controversy. Now what the defendant can do is go to the court, request an order from the court for a physical exam regarding the plaintiff's vision. What the defendant couldn't do, so here, defendant, Rule 35 motion, okay. This is Rule 5, they say Rule 35. All right, my bad. Okay, in motion, you can barely read that, huh? Let's try that a little bit better. All right, say the motion seeks first physical examination of eyes, right? Well, that is probably going to be granted. Suppose the defendant also wants a mental exam of plaintiff's SOM, state of mind, okay? Well, that should probably be denied, right? In what way is the plaintiff's mental state relevant and in controversy? I don't see it, okay? So the mental or physical state has to be in controversy in order for the court to grant that order for a mental or physical examination. And I'm not going to go to the other parts of the rules. Like I said, this is a short video. Hope this is helpful. Have a good one. This is Professor Nathenson, over and out.